Hello, everybody. How are you doing this fine Sunday? I thought today we could try to catch up on the Diddy docket. I think the last official Diddy docket episode that I did was on document 123. Now, I do think we did cover up to 125 on a separate episode. So here's the docket. We're down to a, a document was actually filed today by Mark Agnifilo, Diddy's lawyer, and that was document 132. So I thought we could catch up today. Okay, so the most recent one I said I think we did was 123. This was the order that the judge basically said, no, you're not getting an evidentiary hearing on that prison sweep. Okay, then there was another letter that was filed. That was document one, that was docket number 124. And this is the letter by the government as to Diddy addressed to the judge from specifically Assistant U.S. Attorney Christy Slavic. This was dated as of January 3rd. And this was about the scheduling document. A lot of this stuff has been resolved, but I do want to go through each thing just so that we definitely touched on each one. The next thing filed was docket number 125. And I would say there's a very sharp division line in excitement, etc., between docket number 123, 124, 125, those ones, and then 126. There's like a big threshold that gets marked at document number 126. You'll see what I mean in just a moment, but let's get to 125. 125 was the order for the schedule. Okay, so Diddy and the government, so Diddy's side and then the Fed's side, they both kind of had their own ideas as to how the rest of the scheduling should be going for this trial. And the judge did, I think, pretty much for the most part side with the government. I don't know, that don't mark my word on that. Just that's neither here nor there. That is what docket number 125 is. It's just the scheduling order, and we can read it a little bit here. It'll kind of tell us some of the things the judge decided. The following schedule will apply in advance of the start of the trial on May 5th. Please see order attached. Okay, so the pretrial motions are going to be due by about a month from today. That's February 17th. Then the replies to the pretrial motions are due by March 10th, 2025. Then the oppositions are due by the 3rd, and then the replies to the oppositions are due by the 10th. Okay, so you see what this is going to be. This is going to be the pretrial motions are February 17th. Then the oppositions to those motions are going to be on March 3rd. And then replies to those oppositions will be on March 10th, which would be a week later. All right. So then there was another document. It was document 126. Okay. You're going to be asking, what was document 126? Why isn't it on there anymore? Well, if you look down right below 127, there's this bright, bold blue caps message. It says deleted document. Deleted document number 126 motion as to Sean Combs. The document was incorrectly filed in this case. And I don't know what AP means, but this was entered on January 15th. Well, if you look one position beyond 126, the next thing is 127. And this is a letter motion addressed to the judge. Okay, the motion is one that we've gotten familiar with seeing these letter motions from all these parties, including Busby, including Spiro, and all of them. I mean, they love a letter motion. Okay, so there's a letter motion at 127, and it's the feds saying, Your Honor, Agnifilo did something improper. He effed up. He entered in some stuff wasn't supposed to even be on there. That 126 needs to be struck right now from the record, and then the judge did take it down from the record. Okay, so let's look at what 127 actually says. That is the letter motion addressed to the judge. And this is the one where the feds are like, Your Honor, you have to take that down immediately, please, because that was not supposed to have been filed. Okay, so this is docket 127. Don't worry, we're going to get to 126, but we're going to read it in its present form up on the docket, which is at, I think, 129 or something like that. But I'll show y'all. First things first, we do know that 126 has been deleted, and now this is 127, and 127 being filed is a big reason why 126 was deleted. So let's read it. It's only 2 pages long. It was filed on January 14th. It's from the feds, and it says, Dear Judge Subramanian, The government respectfully submits this letter to request that the court direct the defendant's January 14th letter motion to amend the protective order be removed from the docket and refiled with appropriate redactions that comport with the requirements of the protective order in this case. The motion seeks an amendment to the protective order related to certain videos that have been made available to the lawyers in this case and to Diddy for inspection only and not electronically produced. So there's certain videos, okay? That's what's at issue in this particular conflict that we're talking about right now at docket 127. There are some videos that Mark Agnifilo and Diddy and Diddy's team, they want to get the judge's permission to do some things with that video under this protective order about the evidence. Remember the protective order that was entered into that had rules about how the parties could talk about the evidence, what they could do with the evidence. Certain stuff was going to be attorney's eyes only, certain stuff was going to be inspection only, certain stuff, all of that, right? Well, Mark Agnifilo and Diddy's lawyers are saying they want to amend the protective order because there's certain videos that are at issue here that right now that Diddy can only inspect and are inspection only. But Mark Agnifilo is saying that they want to be able to have a hard copy of the video. But the feds are saying, all right, so the feds are laying that out. And they're saying, okay, but in making his motion, the redactions were incomplete. And the defendant has therefore violated the protective order that he now seeks to amend. So, the irony. The videos, which depict a certain type of content, y'all can read it right here if you really so desire, and undressed folks, they are designated, quote, attorney's eyes only by the protective order. And then they go ahead and they do cite that protective order. You can pause and read that if you want to right there. The letter goes on. The feds say the protective order makes clear that the defense shall not share any attorney's eyes only material or the content of the attorney's eyes only material with any other persons, subject to the carve out allowing for Diddy to inspect the videos. Further, attorney's eyes only material is designated, quote, sealed. These are supposed to be sealed records under the protective order, meaning that any portion of such material cannot be publicly filed on the docket unless it is filed under seal. Okay, so it has to be filed under seal, or the parties have to first confer regarding the sealed designation. Under this protective order, no portion of the videos should have been filed on the public docket without being filed under seal or without first allowing the defense and the government to confer on the designation. Neither one of these things occurred. Instead of conferring in advance or redacting all content related to the videos, the motion blatantly violated the protective order when it left unredacted descriptions and characterizations of material that is designated as attorney's eyes only. There is no alternative reading of the protective order other than number one. The substance of the attorney's eyes only material cannot be shared with any other people. And two, the attorney's eyes only material is otherwise designated sealed, meaning that it cannot be filed on the public docket. While the public dissemination of attorney's eyes only material substantially impacts the privacy and the safety of victims, filing attorney's eyes only material under seal in no way prejudices the defendant, as the full substance of the motion will still be before the court. The protective order thus serves to protect the victim's interests and to prevent the defendant, that's Diddy, from, as he did here, selectively and improperly disclosing evidence to the public in advance of trial. The government therefore respectfully requests that the court remove the motion, docket 126, from the PACER and direct Agnifilo to refile the motion with redactions that are appropriate and comply with the protective order of the court. With this motion, the government also submits under seal for the court's review proposed redactions that comply with the protective order. Okay, so when the feds did submit this order, now this was submitted, not this order. When they did submit this letter motion, this was on the 14th, about 5 days ago. Today's the 19th. Okay, so what the feds did was they submitted their own version of the filing with stuff crossed out showing the judge this is what they think it should be for now until they can confer on the matter. It does appear that the judge did adopt the feds redactions, but there's no way for me to know for sure at this point. I'll read you what makes me think that. After the motion was filed, the government immediately contacted defense counsel, that's Diddy's lawyers, requesting that additional redactions be made. And Diddy's attorneys responded that, quote, they disagreed with the government's view of the protective order. So basically, Agnifilo told him to F off, or whoever it was. I shouldn't say Magnifilo. I don't know if it was Agnifilo for sure. It might have been Shapiro or somebody else. But then the feds say, finally, the government respectfully requests that it be permitted to file its opposition to the motion within 2 weeks by January 28th. The defendant takes no position on this request. Okay. So that was number 127. Okay. And that did, like I said, that resulted in 126 being taken off of the docket completely. And I showed y'all earlier, there's just that blue thing there now. Actually, might as well just pull it up. Let me show you. So as you can see, it did get deleted. 126 got taken off based on this 127 letter. Okay, and then we will look at 128. 128 is just the same repeat of 127, but it's the judge stamping it as, yes, this has been ordered. And it has his little blue ink on it. You know how he normally has that. So this is 128. I'm going to pull it up so you can see it. Okay, here is that letter. And see, it used to kind of say 127 at the top. Now it's 128. It's the same letter we just read. And now it's just the judge has his little blue letters here. Granted, the clerk of court is respectfully directed to strike the motion at docket 126 from the public docket and terminate the motion at 127. Defense counsel, that's Diddy's lawyer, should refile the motion with the appropriate redactions. If he refiles the motion, the government may respond by the 28th of January. It is so ordered. Okay. So that was docket 128. It's just the judge ordering, yes, take it off, calendar, take it off. You know, Agnifilo is going to have to just refile if he wants to have it up. Okay, so now we are at docket 129. And this is a 7-page long letter. It's a lot of stuff in here. I'm not going to get into all of it because I do think it is Agnifilo just going above and beyond to put a bunch of details in here that's irrelevant for the present state as what we're at right now. Plus, there are some more documents I do want to get to before the end of this video. So I just want to briefly go over this letter. This is formerly document number 126. Now, because 127 got it taken off and then 128 was the judge's order, now we're at 129. And this is the further redacted letter. Now, what is this letter? What does it want? Just to remind you, it is Agnifilo and Diddy saying that they want to amend the protective order. They want Diddy to have more access to a certain video. Now, I do believe that these videos have to do with the FO tapes in the alleged. I'll say alleged because it is up for dispute whether they are FO tapes or not. Okay. Diddy and Agnifilo are strongly and aggressively arguing, no, they are not. These are S tapes that were made consensually by consenting adults. That's the gist, I believe, of this letter. We write on behalf of our client, Sean Combs, to request a modification to the terms of the protective order at docket 26 to require the government to electronically produce the videos described in their indictment. The protective order includes a novel provision making this video evidence available for inspection only, and it is not electronically produced. Having reviewed these videos, it is now abundantly clear they confirm Diddy's innocence. Okay, so this is coming from Diddy's side. Okay, don't shoot the messenger. I'm just telling y'all what it says on the letter right here. Their full exculpatory value cannot be investigated and used unless they are electronically produced. Rule 16A1E expressly requires production of copies of such materials to the defense, and there is no plausible good cause to restrict access to them under the rules. The government keeps talking about these being FO tapes, but they're not FO tapes, according to Diddy and Agnifilo and his lawyers. According to them, these are consensual activities among adults. He says at the bottom of this case is about whether victim one, who is the person who was depicted in the hotel footage tapes, which we all believe is Cassie. That's what I believe. Victim 1 was or was not a willing participant in her private S life with Combs. Soon after Mr. Combs was charged, the parties began negotiating the terms of a protective order. During those negotiations, Diddy says, the government insisted, over defense's objection, that certain videos obtained from Cassie and depicting alleged freak-offs were not to be electronically produced, and they would instead only be made available for inspection only, in-person viewing, while monitored by law enforcement. The government explained that Victim 1, whose attorney gave these videos to the government, requested that they not be produced to protect her privacy and that the government would honor the request. To ensure we would receive discovery without further delay, the defense agreed to receive the discovery under those conditions, but while reserving the right in the proposed order to later seek modifications of designations from the court. And so basically he's saying now we're exercising that right. He says that this is not the type of video that this would normally apply to. Normally it would need to be a child or something like that. And because Cassie is an adult, there's no legal reason to keep the video from Diddy. So y'all understand that he wants the video itself. He doesn't want to have to only look at the video. And I think that's why we got like drama channels and stuff saying like, oh, Diddy wants to leak the videos in the prison. I mean, that is not what that says in here. But that was docket number 129. So now we have another letter from Agnifilo at 1:30. Another letter from Agnifilo. 1:30. Okay, so this is his response to his docket number 126. At 126, remember, the judge took his stuff off calendar. The judge said, no, take it down, refile with the right redactions. So here's Agnifilo piping back up about that. He's kind of getting his words in on that now. Dear Your Honor, we write in response to the government's letter requesting redactions to our January 14th motion. At the direction of the court, the letter motion has been refiled with the government's requested redactions. Nevertheless, we still write in opposition to the government's proposed redactions, as overbroad and inconsistent with the presumption of public access to judicial documents. And we seek leave to refile the letter motion with the narrower redactions. So he wants to refile the letter how he first had it filed. As an initial matter, the defense, this is Diddy's general characterizations of evidence did not disclose the content of the attorney's eyes only material. A general description of the nature of the evidence with specific descriptions and additional details redacted is perfectly consistent with the language of the protective order. Okay, so now they're it's hard for me to really do any type of analysis here because it has been redacted. Document 126 has been redacted. And so what's really beneath those redactions, we can't really speak to. I mean, they weren't supposed to be filed, all of that, right? So it's not even on the docket anymore. But Agnifilo wants to put it back on the docket. He's saying this is especially true when the existence of the evidence is already public and the government has regularly provided its own characterizations of this evidence. It has publicized, quote, extended S acts with male commercial S workers, quote, elaborate and produced S performances that were, quote, electronically recorded, publicizing that, quote, during the FOs, alleged victims were subjected to, quote, physical, emotional, and verbal abuse, including being, quote, hit, kicked, and, quote, dragged, and that alleged victims' claims were corroborated by videos of the, quote, FOs. Agnifilo says, even assuming the defense's general characterization of evidence without additional detail is covered by the protective order, which it is not, it's not a valid basis for sealing. Okay, so he's saying, okay, Agnifilo is saying, I didn't characterize, I guess they're talking about how Agnifilo characterized these videos as like consensual recordings between adults or whatever, like consensual activities between adults or whatever. And I guess the government is saying that the fact that he did that at all is not allowed. And Agnifilo is saying, I didn't do that, but even if I did, it is allowed. That's not a basis for redacting something. In determining if a document should be publicly accessible, a court has to look at the following factors. Number one, determine if it is a judicial document. Number two, determine the weight of the presumption of access attached to it. So how much access, how much is it presumed that we, the public, should have access to that information, that document? Right now, we're talking about redactions. So I do believe this is about the public. And number three, to balance the countervailing interests against the presumption of access to the public. So this puts the public in a weird spot, right? Because a lot of the public wants to be like, well, we're on Cassie's side. Believe all victims, no matter what, even if that means we have to give up some of our rights to public documents, that's okay. But on the other hand, y'all aren't saying the same thing when it comes to Diddy's jail raid documents. Do you see what I mean? And I understand that y'all are not as sympathetic, some of y'all, to Diddy as you are to Cassie. But it doesn't really matter about sympathy. What matters is you have to have a fair trial, and it really does need to be fair on both sides. So when it comes down to this argument, I don't know if this will be convincing or compelling to the judge, but I can at least see where Agnifilo is coming from here, because what he's talking about here is the public's right to access. He's not talking about Diddy's right to look at the video on the camera. No, no, no. He's talking about right here in document 130, we're talking about the public's right to see what was redacted in those extra redactions. And we do know, just from looking at, for example, Wendy Williams's guardianship, that there are courts in this jurisdiction that are happy to overseal from the public. So there are these balancing interests that you do have to take into consideration. As we got a little scale back there. Wait, where? See her down there? Anyway, okay. Because the motion to amend the protective order is useful. Okay, so Agnifilo is saying it's a motion to amend a protective order, so the public has a right to see that. The reason being it is, quote, useful in the judicial process. Judicial. The presumption of the public access applies. So yes, it is a judicial document. So then he's going to move to the next prong in the analysis. The right of access prevails unless it is overcome by specific on the record findings that the sealing is necessary. Okay. So the findings have to be on the record. Okay. This is a strong argument, I believe, on the part of Agnifilo, because he is saying, Your Honor, you can't just say, okay, yeah, what the government says, whatever the Fed says goes. Nope. You have to make those findings on the record. It can't be ex parte like how you did it. You have to find on the record that sealing is necessary to preserve higher values, and only if the sealing order is narrowly tailored to achieve that aim. Broad, general, and conclusory findings are insufficient. Moreover, any competing justification provided by the government would not outweigh the presumption of public access. Okay, so I think these are pretty strong arguments. I'm not saying they're strong enough to prevail, but I'm saying I don't believe they're frivolous. I think I could see where he's coming from. And if I were Diddy, I would hope my lawyers would be making that type of argument. As far as my opinion on it, I don't really know where the judge is going to come out. I mean, if I had to guess, the judge kind of already made a call. But again, it really wasn't on the record. It was off the record as far as what I could tell. So now we're going to go to document number 131. And this one was just filed yesterday. This one is the second to last document we're going to be looking at. There was one actually, again, like I said earlier, filed today. This one, this is 10 pages long. So we're not going to be going through every word of the document. But this one was dated as of 2 days ago, but it hit the docket, it looks like, on the 18th. This is a letter from the feds, docket 131. The government respectfully submits the attached declarations in response to the court's order in further support of its opposition to Diddy's motion for a hearing and other relief. Okay, so do y'all remember whenever the judge, it was like earlier this month, it was almost a month ago at this point, but whenever the judge told the feds that he wanted some information from them, and this was based on some things that Diddy and Agnifilo and Alexandra Shapiro had said to the judge in this case. The judge said that he wanted from the feds a few things. One thing he wanted was an affidavit or a declaration from the investigator one, the guy, or yeah, it was the guy who was interviewing Diddy and interrogating him, but he was also the one who took pictures of the legal pad notes from Diddy's locker and stuff like that. We're still kind of dealing with the hanging on of all of that. The judge had said he wanted to see certain documents, affidavits, declarations from certain people on the side of the feds. So this document here, 131, is the feds giving over to the court those requested documents. This was at docket 117 whenever the judge had asked for those declarations. Oh no, sorry, excuse me. That was at docket 123 where the judge had asked for those declarations, and then it was related also to 117. At the request of the Bureau of Prisons, the government respectfully seeks to file the declaration attached as Exhibit B under seal. Okay, so Exhibit B, they want to put it under seal. And this is going to come up. It's really ironic that the last document we read had to do with the public's right to access, and the counterbalancing interests that might be at play. Now, here's another place where this is going to come at issue. I could imagine that DIDDY and Agnifilo and Alexandra Shapiro and them are going to want the public to know who Investigator B is and want to know his signature and all of that. I doubt they're going to want to make that public because it appears that the Bureau of Prisons has specifically requested that it not be public. Look, at the request of the Bureau of Prisons, the feds say, the government respectfully seeks to file the declaration attached as Exhibit B under seal. Based on communications with counsel from the Bureau of Prisons, the government understands that the information contained therein reveals sensitive law enforcement techniques and reveals the identity of an employee involved in an ongoing BOP-led investigation. So they are going to try to assert the law enforcement privilege, preventing disclosure of law enforcement techniques and procedures, and protecting law enforcement personnel, safeguarding the privacy of individuals involved in an ongoing investigation. Finally, with respect to Exhibit A, the prosecution team declaration, the government provides information requested by the court, but in so doing does not waive any applicable privilege, including law enforcement privilege and deliberative process privilege. Okay. The government remains available. Okay, so then Exhibit A, this is Christy Slavik's declaration. I've been investigating this case since 2024. I submit this declaration in response to the court's order based on my personal knowledge, based on my discussions with the United States Attorney's Office, Southern District of New York unit chief, who directly supervises the prosecution team, and the prosecution of the defendant, Supervisor 1. I have learned that on or about October 10th, 2024, Bureau of Prisons personnel contacted Supervisor 1, so her supervisor. So she's saying, all right, Christy Slavik is saying, all right, my supervisor was contacted in October by the Bureau of Prisons and informed that a Bureau of Prisons intelligence analyst, okay, so that's Investigator 1. He is a Bureau of Prisons intelligence analyst. He had been monitoring the defendant's communications from the MDC. He had been monitoring Diddy's communications from the prison and had found apparent attempts to circumvent monitoring, as well as the use of coded language. Okay. This intelligence analyst also talked about possible attempts to engage in witness intimidation. The same day, the U.S. Attorney Supervisor requested transactional data, which is the defendant's email and phone contact list, and the defendant's emails from the Bureau of Prisons. Christy Slavik says she served the Bureau of Prisons with a grand jury subpoena for non-attorney phone calls. So she said, I asked only for non-attorney phone calls placed to or from Diddy. Since that time, I've been the member of the prosecution team primarily responsible for liaising with the Bureau of Prisons, including Investigator 1, who is the Bureau of Prisons intelligence analyst. On or about October 13th, 2024, I spoke with this investigator who provided an overview of some of the defendant's calls that he had monitored. Investigator 1 also detailed the unauthorized methods of communications the defendant was using. That's Diddy. Investigator 1 also detailed the, quote, unauthorized methods of communications that Diddy was using, including using other inmates' prison access code numbers, their phone access code numbers, using three-way calling, using third-party messaging services. I spoke with Investigator 1 on several other occasions in October and November 24. Then she talks about planning for the sweep. Based on my discussions with another U.S. Assistant Attorney, Unit Chief, who does not supervise the prosecution team or otherwise have any involvement in the defendant's prosecution. This was her other supervisor, Supervisor 2. Through that person, I learned that beginning in or around June 2024, maybe July 2024, the Bureau of Prisons and the United States Department of Justice Office of the Inspector General began planning a large-scale search of the MDC for contraband. So this had been being planned since June or July 2024. The Bureau of Prisons and the United States Department of Justice Office, the Bureau of Prisons and the Office of Inspector General, who were responsible for the execution of the MDC sweep, hosted a series of status calls with the participating federal agencies. as well as representatives from the attorney's office in the SDNY, where we're charging this case, and in the Eastern District as well. Supervisor 2 was present on these calls. Okay, so she's saying the Supervisor 2 is the one who knew about this. And as we're telling you up here, he is not a supervisor of this prosecution team, and he does not have any involvement in the defendant's prosecution at all. This is the man who was on all these status calls. Okay, so he was not supervising us. Based on my conversations with members of the prosecution team, I have learned that no member of the prosecution team was involved in planning the MDC sweep. Further, as described in paragraph 7, prior to October 28th, no member of the prosecution team was even aware of the sweep. Based on my review of the email communications, I learned that on or about October 28th, the Bureau of Prisons and other federal agencies began executing the planned sweep. That day, the sweep was already in progress. Members of the prosecution team then learned of the sweep when Supervisor 2 sent an email to all assistant United States attorneys in the criminal division. The office-wide email informed all of us that the sweep was a pre-planned, large-scale search of the prison in response to persistent contraband issues at the place. It further stated that the MDC sweep was not the result of any specific intelligence or threat. I understood from the office-wide email that it was expected that contraband, which would be like narcotics, weapons, electronic devices, could be seized from defendants, even DIDDY, during the sweep, and that assistant U.S. attorneys may be contacted about contraband seized from the defendants in their assigned cases. Based on my conversations with Supervisor 2, who, as described above, is not part of the prosecution team, but had a role in coordinating with those responsible for planning the sweep, when I talked to him, I learned that the sweep continued through November 1st and that he was at the MDC on or about October 28th and on or about the morning of the 29th as well, to ensure legal issues involving any USAO SDNY defendants were addressed and to relay information to the assistant U.S. attorneys who were prosecuting defendants from whom contraband had been seized. Based on my review of public reporting, I am aware that on October 28, 2024, various media outlets reported that there was an interagency operation at the MDC where Sean Combs, the defendant, was housed. See, quote, authorities launch interagency operation at federal jail in New York, housing Sean Diddy Combs. Based on my conversations with Supervisor 2, I have learned that on or about the morning of the 29th, following the completion of the first day of the sweep, representatives from both the Bureau of Prisons, federal agencies, and the United States Attorney's Office, SDNY, including Supervisor 2, and from the Eastern District, they all met regarding the ongoing execution of the sweep. And they discussed various issues that had arisen, including the amount of time that the search was taking and a potential search of a unit located in the East Building of the MDC. This is Unit 1. Unit 1 is non-general population where the defendant, along with other inmates, is housed. The agencies conducting the search inquired into, among other things, the position of the U.S. Attorney regarding the potential search of Unit 1. Supervisor 2 had responded that he had understood that the MDC sweep would include searching Unit 1, but that he would confer with senior leadership at the Southern District. Based on my conversations with Supervisor 1 and 2 and my review of the communications, I have learned that on or about October 29, 2024, Supervisor 2 informed Supervisor 1 that the sweep of the west side of the MDC was taking longer than expected, and it was unclear whether the east side would be searched. Supervisor 1 informed Supervisor 2 that in her view, okay, so Supervisor 1 must be a she, okay, so we have a she. Supervisor 1 informed Supervisor 2 that in Supervisor 1's view, the sweep should include the east side of the MDC as planned, in part because of what the prosecution team had learned regarding the defendant's conduct at the MDC. At the request of Supervisor 2, Supervisor 1 conferred with the Southern District senior leadership about the search of the east side of the jail. This is where Diddy was. So they're going back and forth of like, should they search Diddy's cell? Should they not? So was this before he had been searched or after? It's unclear to me. It looks like this is before. The conversation included that the sweep was taking longer than expected, and it did not include discussion of Diddy. Thereafter, Supervisor 1, this is the one that works on the prosecution team again, relayed to Supervisor 2, which is the one that does not work on the prosecution team, that the position of the U.S. Attorney's Office Southern District was the MDC sweep should stick to the original plan and search the entire jail. Supervisor 2 relayed to other personnel present. Okay, so what they're saying here is, yes, there was discussion of Diddy's unit, Unit 1, but he's not the only person over there. And the discussion was simply, don't do anything special based on somebody in that unit or not. If the plan was to search the whole jail before, you need to still search the whole jail. We're not going to change any plans based on anybody special. No, that's what's being presented to us. I don't know if that's what happened, but that's what the government, the feds are saying happened. Based on my conversations with Supervisor 1 and 2, I have learned that no Southern District of New York personnel in the U.S. Attorney's Office directed how the search of Unit 1 would be conducted, or whether any particular area or bunk within Unit 1 or any particular inmate's possessions should be searched. In addition, no U.S. Attorney's Office SDNY personnel were aware that Investigator 1 would be involved in the MDC sweep. Okay, so this is very important. This is something that the judge did want to know. None of our personnel were aware that Investigator 1 was going to be involved in this sweep. Other than Supervisor 2, who is not part of the prosecution team, no U.S. Attorney's Office SDNY personnel had even any awareness of the specific details of the MDC sweep or their operational plan. Based on my November 3rd, 2024 communications with Investigator 1, described at paragraph 16, I have learned that Unit 1 was searched on November 1st, 2024. Based on my conversations with Supervisor 2, I have further learned that neither Supervisor 2 nor any other U.S. Attorney's Office SDNY personnel directed or was aware during the search of Unit 1 that Diddy's bunk area or possessions would be searched in any manner inconsistent with the BOP's overall plan to execute the MDC sweep to locate contraband. Neither Supervisor 2 nor any USAO SDNY personnel directed any of the defendant's possessions to be seized or photographed. And we also were not aware that that had happened until after the search was over. Based on my participation in this prosecution and my conversations with other members of the prosecution team, I know that prior to and during the MDC sweep, no member of the prosecution team communicated with Investigator 1 or any other BOP personnel or federal agents conducting any part of the sweep about the search of Unit 1 until after it was over. On or about November 3rd, following the completion of the sweep, the prosecution team first became aware of Investigator 1's involvement in the sweep through a phone call between Christy Slavic and this Bureau of Prison intelligence analyst, Investigator 1. Investigator 1, at that point on that phone call, after the sweep was already over, informed me that he had spent time in Diddy's unit and checked Diddy's bunk area for contraband, including cell phones. Investigator 1 also informed me that he took photographs of certain of Diddy's papers and an address book. He also provided a high-level overview of the contents of the notes, including the defendant's plans to discredit possible witnesses and find dirt on people. At the conclusion of the November 3rd, 2023 call, I requested that Investigator 1 send the notes directly to the filter team. By email later that day, he confirmed that he had sent the notes directly to the filter team. Okay, so that is the end of that. And again, there was something about Investigator 1, but they didn't even put a redacted on there. They just completely filed under complete and total seal. Now, Agnifilo has responded today, January 19th, and this is what he had to say. He was not very long-winded today. We have reviewed the government's submission and closing affidavits from U.S. Attorney Christy Slavic and Investigator 1. Agnifilo says, we respectfully request permission to respond to these affidavits in further support of Diddy's motion for a hearing by Friday, January 24th. Thank you for your consideration. Okay, so Agnifilo wants to respond and he's asking the court if he can do so. That was all that we had up until today. Like I said, Sunday, January 19th. What is still outstanding is whether or not it was proper for the government to get those notes in that way. And Diddy and Agnifilo are asking for a lot of relief, and Alexandra Shapiro as well. They're asking for a lot of different versions of relief. They're asking for up to dismissal. They're asking for a different, separate, new filter team that's not connected with the prosecutor's office to come in. They're asking for possibly to have these prosecutors who did see those notes recused. There's a lot still to be decided, but I did want to get us caught up through docket number 132. The next one we're going to be looking at, whatever it may be, is going to be docket number 133. So I will see you then. In the meantime, facts ain't defamation. Neither are opinions. Squirrel, love you. Okay, bye.